Here are the topics that are covered in the US Constitution revision video. This video is going to focus on amending the US Constitution as well as analysing the positives and negatives of that process. Would you consider the US Constitution to be flexible? It can be considered flexible because the articles of the Constitution grant enumerated powers, but there are also implied powers. There are powers that the Constitution does not explicitly mention, but might be reasonably implied by the articles. For example, Congress has the enumerated power to raise an army and navy. It might therefore be implied that they have the power to draft people into these forces. Similarly, the power of Congress to levy and collect taxes might be implied from their delegated power to provide for the common defense and general welfare of the United States. It can be considered inflexible because its codified nature and complex amendment process makes it difficult to change. The Constitution was made deliberately hard to amend formally. There are two ways in which formal amendments can occur. In the vast majority of successful amendments, the process begins with Congress and it is followed by ratification by individual state legislatures. In both cases, a high threshold of approval is required. In one case, the 21st Amendment that repealed prohibition, ratification occurred via ratifying conventions in individual states. There is a provision for amendments to be proposed by 2/3 of the states calling for a national constitutional convention, but this has never been successful. The closest it has come in recent times was in 1992, when 32 states petitioned Congress for a convention to propose a balanced budget amendment. This fell 2 states short of the threshold, so the plan failed. Before evaluating the amendment process, we should highlight a few basic facts about constitutional amendments. There have been 27 successful amendments, 10 of which were passed very soon after the Constitution was ratified. Together, they are now known as the 1971 Bill of Rights. The amendments deal with a wide range of topics, but among those several concern individual rights and also voting. The last major amendment, the 26th, lowered the minimum voting age from 21 to 18. One amendment overturned an earlier one. This dealt with prohibition, so there are only 25 current live amendments. Many of those amendments were passed in response to a particular situation or context. For example, the amendment restricting the president to 2 terms in office was passed soon after the lengthy presidency of FDR, who served for an unprecedented 13 years, having won 4 successive elections and died in office in 1945. Not all amendments have equal significance. The 23rd Amendment gave Washington, D.C. votes in the Presidential Electoral College. This is important for D.C. certainly, but perhaps not quite significant as enfranchising women or ending slavery. Key amendments from the Bill of Rights include the First Amendment, which introduced freedom of religion, speech, the press and assembly, the Second Amendment, which introduced the right to bear arms, the Eighth Amendment, which banned the use of cruel and unusual punishments. Key amendments after the Bill of Rights include the 13th Amendment, which abolished slavery, the 14th Amendment, which gave citizenship to former enslaved people and included the Equal Protection and Due Process Clause, the 17th Amendment, which introduced the direction to the Senate. The last amendment to be passed was in 1992 and specified that any increase to congressional salaries could only take effect after the next election. Numerous amendments have been proposed, and 6 today, including the Equal Rights Amendment, which would have embedded women's rights into the Constitution, have been passed by Congress but failed to get significant state ratifications within the allocated timeframe. Although formal ratification is rare and difficult, informal amendment via the judgments of the Supreme Court is far more common, and arguably enables the Constitution to remain relevant and up to date. There is an argument that the US Constitution is too hard to amend formally. Let's look at both sides of this argument. On one hand, it can be argued that the Constitution is too hard to amend formally, as very few amendments have been passed recently due to the high thresholds required. 27 in over 200 years is not an impressive achievement. The current Constitution contains some provisions that many consider outdated, for example, the Electoral College and the Second Amendment. It prevents the Constitution from being updated, especially in the area of rights. While some key groups are protected, such as racial minorities, others, such as women and people with disabilities, are not. The complexities of passing amendments make this almost impossible to achieve. Too much informal amendments takes place via the Supreme Court judgments from individuals who are unelected and unaccountable. Although in theory this can initiate the formal amendment process under Article 5, no national constitutional convention has ever been held. However, it could be argued that actually the US Constitution isn't too hard to amend formally, as the high thresholds for a formal amendment ensure that the change only happens when there is a wide consensus and broad agreement. Absolute clauses of the Constitution can be repealed, as happened with Prohibition. Some constitutional problems, such as the Electoral College, could be reformed without the need for outright abolition. Some aspects, such as the Second Amendment, are capable of sensible adjustment, including banning the sale of certain weapons or requiring background checks. The rights of many groups not specifically singled out for protection in the Constitution can be equally well defended by federal and state laws. If constitutional amendments were made much easier, where would the line be drawn? While protecting the rights of women and children might receive near universal support, those of transsexuals or vegetarians might be more complicated and controversial. The Constitution is primarily updated via Supreme Court judgments and not through the formal process of amendment. The Court has a crucial role in interpreting the Constitution via judicial review. This has led to judges to discover new meanings and rights within existing clauses. Aside from Roe v. Wade, other examples of this would include the explicit right to provide gun ownership as a result of District of Columbia versus Heller, the right of those stopped by the police to remain silent and avoid self-incrimination, the so-called Miranda rights, the right of corporations and interest groups to enjoy First Amendment rights, extending the notion of free speech to political activity and organisation following the Citizens United case, the rights of LGBTQ plus Americans in the Obergefell versus Hodges case, and extending the right of privacy to mobile phones data in Carpenter versus the United States.